You're our Jermika August.
Yes.
And this is 21-36752. And Ms. August is currently on probation for, looks like the state jail felony offense of unauthorized use of a vehicle. And there's a motion to revoke that probation.
Yes, sir.
And so where are y'all on?
We have not entered pleas on this case, Judge. We have discussed if the court would consider entertaining a 1244 due to the fact that she has recently found out that she was pregnant. I think her involvement in this offense would suggest that 1244 might be something to consider, but in all honesty, I didn't send the paperwork because if she's pregnant, if she's having all these issues with the positive test that Ms. Kane can discuss, it just, I want to help her. I want to help the baby more than I want to help her, but I know they won't take her in any of our programs because of that. She's been extended on probation, so
Yes, ma'am.
she's towards the end, and it's my understanding from Ms. Holmes, who's worked very hard on it, that she just wants to sit out her time, but you understand my concern with the situation that she's in. It may not be the right thing to do, just to let her go sit there for a little bit of time, and then we have no idea what she's doing and she's pregnant.
And in regards to, I know there was a recent drug patch result. So Ms. August, to my understanding, has denied any substance. The drug patch keeps registering saying cocaine, which was, as I think the results were from last week. And so that's why we asked if she could drug test today, because she has denied being, using those substances. But we do understand the concern, but we wanted to, I guess, shed some light or give, I guess, everyone, let them to breathe a little easier with her taking a test today showing she didn't have anything in her system.
And she tested in court also, it looks like March 2nd, and tested negative.
Right.
And then there was a drug patch that tested negative back in. So there's been kind of both. How far along are you? That was.
You know how far along you're pregnant?
I just found out literally like four days ago. My first trimester. So
I mean, it's the type of case and the type of issues on a case that a 1244 has been fairly normal. I understand and have the same concerns, but I don't know that forcing anything is the thing to do, or if it's the fair thing to do either.
I just wanted
Yeah.
these issues to be.
I'm with you on
aware.
what I'm concerned about, Miss August. I mean, we're both concerned, and I know everyone here, your probation officer, even your attorney, we're concerned about your baby. My concern for you kind of goes away once I know that you are with child and have had some issues with drugs. We want your baby to be safe, but you've also been on probation for state jail felony for longer than you would have been doing state jail time with some hiccups. So it makes sense what they're talking about, but if you're having issues, you need to do whatever you need to do to be safe and have your baby be safe. Okay.
I'll send that paperwork.
Thank you. All right. I'll take care of it. Y'all have a seat and I'll take care of it as soon as it comes through.
Okay.
And is the intention for Miss August to go today and be
Yes, ma'am.
sentenced? Okay. And all right, ma'am, again, you are Jamaica August.
yes,
And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. August, in cause number 21-36752, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation November 28th of 2022 for the state jail felony offense of unauthorized use of a vehicle. And that was a 2-year deferred probation, and that's been extended. Is that correct?
yes,
It alleges you violated your probation. Count 1 alleges that you committed the new offense of resisting arrest, search, or transport on August 10th of 2025. Is that true or not true?
it's true.
Count 2 alleges that you committed the offense of criminal trespass on August 10th of 2025. And is that true or not true? Count 3 alleges that you failed to remain off the premises of any bar, tavern, or lounge, and that you were at Little Woodrow's August 10th of 2025. Is that true or not true?
Sure.
Count 4 alleges that you were at a location other than your residence at approximately 1:37 a.m. on August 10th of 2025. Is that true or not true? Count 5 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample July 29th of 2025 that tested positive for marijuana. Is that true or not true? And then count 6 alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have here on the tablet some documents that, oh, it's county jail, not state jail. Correct.
Plus 44, yes.
Okay. There's a spot for county jail.
Yes.
With y'all's permission, I'll
Yes,
make
ma'am.
that change. Okay, I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. August is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. And at this time, I find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 8 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. I really do. We all hope that you make the changes that you need to, so you can raise your babies and nobody else. All right, you can go back. Good morning. You're Jaleisha Wade, and Ms. Wade was previously in court, entered a plea of guilty to aggravated perjury. The agreement was for probation. The length of time and type of probation was all left up to the court. Is that correct?
Yes, Your Honor.
And I've received that pre-sentence report as well as some letters that the defense counsel has provided of support for Ms. Wade. Has everyone had an opportunity to review all of that?
Yes, Your Honor.
Are there any additions or corrections to that pre-sentence report?
The only correction, it stated that Mrs. Wade's driver's license had expired, but it's expired in 2030. So her driver's license
Okay.
is good. So that's the only.
Okay. Mr. Coleman?
Nothing with regard to the PSI, just a brief argument. It is on the court's ready here.
Sure. Ms. Holmes, I'll let you go ahead with the argument.
Yes, Your Honor. Thank you. Your Honor, I've had the opportunity to speak with Ms. Wade on several occasions, and in regards to this aggravated perjury, this is a third-degree felony. Ms. Wade, prior to this happening, has no criminal history, zero criminal history. The only thing is on the date of this incident at this trail ride, Zydeco, she was in an altercation with a young lady in which she was charged with an assault, in which she has successfully completed deferred adjudication for the misdemeanor. She has no felony criminal history. She understands the ramifications and of being untruthful in regards to who she was in a car with. She was a passenger in a vehicle, and that is what she was indicted for, as to being untruthful as to who all was in this vehicle that she was a passenger in. Your Honor, we understand when testifying, when she was subpoenaed to testify in front of this grand jury, that you need to be truthful, and she understands that moving forward. She wants that opportunity to show that she can be, obviously, continue to be a productive citizen in society, and she's asking for that second chance. We are obviously asking for a deferred adjudication in this matter. We believe that this is a case that should be afforded that opportunity for Ms. Wade. She is a single parent who provides for her son. She works hard. He has, as I stated, no other history. And as you can see on the evaluation in this PSI, it's indicated a low risk level, which we feel is very important for the court to know, because it suggests that offenders who are rated as low often self-corrects. And we believe that Ms. Wade will self-correct and understand her actions moving forward in life, but we do want her to have that second chance to be able to complete a deferred adjudication so she does not have a felony conviction on her record. We know that this is a court of second chances. We've seen several times people who I believe sometimes have more heinous crimes that get the opportunity at deferred adjudicated probation. And I believe that Ms. Wade should have that opportunity as well. We do know that obviously it's your decision, Your Honor, in regards to that and in regards to the length of time. Being that this is a third-degree felony, we are asking if the court grants Ms. Wade this deferred adjudication, if it could be in the range of possibly 3 to 5 years as opposed to the maximum 10. It states that she lacks prior felony convictions that suggest that this incident may represent an aberration rather than a pattern of criminal behavior. In addition, it states in this PSI that her stable employment, parental responsibilities, and minimal prior criminal record support the feasibility of probation as a means to rehabilitate rather than to punish. And we feel like having a straight probation will be more of a punishment rather than a rehabilitation so that she can self-correct and be productive and have that opportunity to move forward in life without this conviction. So, Your Honor, we are asking for deferred adjudication in the range of 3 to 5 years if possible, so that Ms. Wade can prove that this will not happen.
Thank you, Ms. Holmes. Mr. Coleman?
Your Honor, Ms. Holmes characterized her lie to the grand jury as just simply a lie about being in who she was in the car with. She lied about being in the car with someone who law enforcement strongly suspects had just shot up an innocent man at a Zydeco trail ride rodeo arena. That's what she lied about, Judge. Law enforcement suspects and has good information that she was present when this innocent man was shot by this suspect who she lied about riding in the car with. Law enforcement has good reason to believe, and I believe as well, that she holds the key, has information that could bring that family of the defendant suggested some closure and help solve that unsolved murder and prosecute the person that's responsible for it, Judge. The nature and the gravity of this offense requires it. Judge, it pains me to even have to offer probation, Judge, but there are certain realities that I have to deal with and that necessitate me making this offer of probation. That family has to live with the loss of their loved one and possibly that crime not being solved. And if they can live with that, Judge, this defendant can live with a felony conviction on her record for not, in my opinion, being completely truthful, providing all the information that she has. It is tantamount to obstruction or hindering a prosecution, what this defendant has done and what she continues to do, Judge. She's fortunate that all I can do at this point is offer straight post-conviction probation and figure out what you're. I am imploring the court, please, to put her on a straight probation, post-conviction probation, Judge, with as many conditions as the court sees fit.
So, Ms. Wade, I don't know if you've been in here all morning, but I've had a couple of tough sentencings. The information that you he's right. You know, you didn't do, we're not just talking about some crime. We're talking about a murder that you lied about. That still, when maybe never will be resolved. So I understand and agree with Mr. Coleman. The other side of that, other than that day, you've never been in trouble. And I don't know if there's a fear, if there's someone pressuring you, or those types of things, which I wouldn't be surprised of based on the people that we were dealing with regard to that murder charge. Ms. Holmes is correct, though, that, there are offers and agreements every day in here for worse offenses, where I do give deferred probation, where people actually shoot people in aggravated assaults and things like that, and robberies. All right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to give you an opportunity today and defer all proceedings and place you on probation. I am going to place you on probation for 10 years. So Ms. Holmes gets part of what she wants, and hopefully Mr. Coleman will feel a little more secure knowing that you will be under watch for up to 10 years. I am going to order a $1,000 fine, order that you follow all of the rules and conditions of probation. Now, that is going to include, and I don't know what relationship you had with anyone that was in that vehicle, but you will be ordered as a condition of your probation to have no contact or communication with any of them. That includes John Gutierrez and Shamar Johnson
and Patrick Charles. Okay, are those the three?
Yes, sir.
Can I say something?
Mhm.
Shamar Johnson is, we have to explain these.
They're related.
We'll be later.
Okay. We can't go to family members. You can't be around them right now until I give you permission to be around them. So if there's a family get together, one of you gets to go and one of you doesn't. That's part of the consequences of your actions. Okay? He was in the truck also, and I don't know what he knows or did, but obviously everybody that was in that vehicle probably has some information about something terrible that happened that day. Otherwise, there wouldn't have been the lies told. So you don't get to be around him, period. Do you understand? Okay. If you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you do not have a felony conviction on your record. Oh, sorry. And if you successfully complete the probation, then you will never have a felony conviction. The case will be dismissed. The other side of that, however, is if you violate any condition of probation at all, you'll be brought back into court and you could be found guilty and you could be sent to prison for up to 10 years. Do you understand? Yes, sir.
Sorry, to interrupt, would the court entertain or at least consider some jail time as a condition of probation? And if any of the alternative, maybe a condition of serving at least 1 day or 1 weekend in jail on the anniversary of the death of the victim.
I'm sorry, Your Honor. She is not charged with murder.
Hold on. I'm not, here's the thing, hold on, it's fine. I appreciate that Miss Richards I'm not going to put her in jail today if she's taking care of a child. But here's the thing, Miss Richards, some people, I'm sorry, wrong, okay, Miss Wade, I was looking at the wrong thing, Miss Wade. A lot of people, and Miss Holmes can tell you this, there was a time where I would give probation, people would come back, they'd mess up, sometimes I'm given some extra chances. Those days are gone. This is your chance. This is your chance. So if you violate, I can assure you that if we're standing in here, this man right here is going to remind me of what I should have done the first time with the conviction and possibly prison or send you to jail up front. So you need to do everything you're supposed to, follow all of the rules. And if you do that, again, this is your opportunity to put this behind you, continue living your life like it looks like the rest of the way you've been living it, other than on that day, hopefully. Right? Makes sense? Did I already hand you? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork.
I think I have a question. She lives in Texas City. I think that's Galveston County. Will she have the opportunity to transfer?
Talk to probation today when she calls you up about where you live, and they'll have to do the appropriate paperwork, and it'll be transferred to where you live.
And just like that, it's over. 8 months. No dramatic outburst. No final plea. No last-minute reversal. Just a quiet decision that changes everything. And what makes this hit harder isn't just the sentence, it's the timing. Pregnant, on the verge of starting a completely new chapter. And instead, she's walking into jail. The judge followed the agreement. Legally everything checks out. But emotionally, this is where people start to feel divided. Was this accountability? Or was this a missed chance to intervene differently? Because now, the consequences don't just belong to her anymore. And that's the part of cases like this that stays with you long after the courtroom clears.